everyone. This is attorney Nicole Huffman of the Law and Legacy Building Firm, or you may know me from Now with Nicole, or my ministry, The Worthy Project. And today I am here to discuss dying without a will in Texas, what couples should know when they have children who are not also the children of their spouse. And this could be a child that was born before the marriage, or can be a child that was born during the marriage. And in that case, you have other issues outside of estate planning, which I'm not going to address here, but it's for any child who's yours who is not also your spouse's. And when it comes to children who are born during the marriage, for instance, who are not your spouses, we then get into the issue of legitimacy, because in Texas, because all this is based on Texas law, if you're just now tuning into this series, it's a part of the Family History Month, and I've been talking about estate planning and just giving different tips for certain subsets of people here in Texas. And this is not meant to be legal advice. I am not assuming an attorney-client relationship. And if you would like more information, please consult an attorney in your local jurisdiction, in your state, in your local jurisdiction. However, a lot of the things that I'm talking about, they should be considered by anyone in any area. Just generally, if you don't have any estate planning done and you're married and you have kids that aren't your spouses, you may want to speak with someone, a lawyer in your area, and talk to them about what could happen with your property once you pass away. So one of the things that we have in Texas is our illegitimate child, if you will, law. And if you have a child who, say for instance, the child was born during the marriage, or the child even could have been born before the marriage, and whether you knew the child was born or not. And what happens is that if you have a child that is not born during a, a marriage, that child is considered to be illegitimate in Texas unless the parents later get married, or if the father has claimed the child on a birth certificate or on some kind of affidavit saying that he's claiming parental rights, or if a DNA test has determined that he is the father, and that could be a DNA test that led to child support during his life, or it could be a DNA test that was done after the father died. So those are the ways that you can prove legitimacy. Thus, if you have a child out there who was born not of your marriage, whether, like I said, it was during your marriage and your spouse knows or maybe doesn't know, or if it was before your marriage and your spouse knows or maybe doesn't know, or maybe you don't even know, there's the possibility that that child, if you don't have a will, if you don't have estate planning documents in place, that child that child will have to be considered is going to be considered in your will. I'm sorry, in your estate. If you when you go to probate in Texas, if you don't have a will, all of your children, whether they were born through the marriage or outside the marriage, they are all going to be considered when the court goes through the probate process. Furthermore, even if the child was not known during the time and there was a will, or if the child was known and the person was trying to disinherit them for whatever reason, there also there also is set up some protection. There's also set up some protection from children when there has not been proven, there's not proof during the father's life that this was their child, for instance. So if it's proven after the father's death, well, yes, this was his child. Well, the child, even if there was a will, if that child is not mentioned anywhere in that will, the child cannot be disinherited. So unless you have put something aside in some trust or some kind of life insurance or something, you can't just disinherit this child who, for all intents and purposes, was illegitimate while you were alive, because you never claimed the child. And so it was never known that this was your child. Therefore, after you die, whether if you die without a will, the child is going to be entitled to a part of your property. If you die with a will and you don't mention this child, you're not going to be able to, you can't just disinherit this child. So you would have to have had something in place in order to, in order for the court not to decide that you were trying to do something sneaky or underhanded, or you're trying to harm the child. In order for them not to still give the child some part of your estate, you need to have something in writing in place that acknowledges that child, if you know the child is there. But that's another issue that comes up, because if you don't even know that this is your child, and later the child's mother pops up during probate and says, well, this is his child, and a DNA test is performed, well, then there, even if you had a will, they're still going, the child is still going to be able to get something from your estate, because the child, because his or her identity was not known, or you didn't know they were your child, and so they can't be disinherited.